Welcome back to the morning show here on the Arise News channel. It's now time to join our Abuja studio for a conversation on the Presidential Election Petition Tribunal, which yesterday affirmed the victory of President Buhari at the 2019 presidential election. And we will be starting with Professor Yusufari Lawan, the Dean, Faculty of Law, Bayero University, Kano. He will be joined later by Senator Ita Enak. Professor Maman, good morning.
Yeah.
Good morning and welcome to the morning show.
Good morning, Professor.
Hello, Prof. Can you hear us?
Yes, I can hear you. Good morning.
Prof, well, quickly, the subject before us is the ruling of the Presidential Election Petition Tribunal yesterday in the matter between Atiku Abubakar and President Muhammadu Buhari, and then the PDP on one hand and the APC. And that tribunal dismissed the petition. What's your take on the ruling by the Presidential Election Petition Tribunal?
Thank you so much for having me. Let me first correct a mistake. I'm a former dean of the Faculty of Law, Bayero University, not the current dean. I must say the decision did not come to us as a surprise. It's a welcome development, and I think I should congratulate the country for having this wonderful decision. And I also congratulate the judiciary for this great achievement. It's a great achievement in the sense that it shows that the democratic process in Nigeria is developing. It also shows that the Nigerian judiciary is up to the task. It can deliver, and it is also making very giant strides in the development of the legal jurisprudence in Nigeria.
Thank you, Prof. But for the benefit of, well, those of us two sitting here and our viewers, can you take us through the issues? Because in the history of election tribunals in Nigeria, the ruling party has never been unseated. I'm going even all the way back to Awolowo and Shagari. In the Fourth Republic, you've had Olufalaye and Olusegun Obasanjo, then President Muhammadu Buhari, 3 times against Olusegun Obasanjo, against Umaru Yar'Adua, and against Goodluck Jonathan. Why is it that this burden of proof that has been established, let's discuss that, and then why has the petitioner never ever succeeded in establishing his case?
Well, I think we need to know that it's very, very difficult to actually unseat a president who has been declared winner and has already started the business of governance. And like you rightly said, we have never seen this kind of thing in this country. And it has to do largely with, I think, the difficulty in prosecuting election petition. The law, I think I can say, favors more the respondent. If you look at the burden of proof placed on the petitioner, it's really very, very hard for him to discharge. If you are looking at the whole country, and if you have as a ground of petition that the respondent, that is the elected president, was not elected by a majority of lawful votes cast at the election, then you will need to show how unlawful the votes were during the election. And you know Nigeria is a very large country with so many polling units, and the requirement is that you will have to prove, for instance, rigging malpractices in a majority of the polling units. And you have to do that polling unit by polling unit. And you know this is a very, very Herculean task. It's not easy to do. In addition, there is the requirement of proof beyond reasonable doubt. If you allege criminal activities during the election, the standard of proof required in law is proof beyond reasonable doubt. And you know how hard it is to prove a thing beyond reasonable doubt. Even in normal criminal cases, the conventional cases, it's actually not easy. And they said election petitions are sui generis. They're in a class of their own. There is a mixture of civil issues and criminal issues. So whenever you raise a criminal issue, you will have to prove it beyond reasonable doubt. And that is a very, very Herculean task. I think that's why the prosecution is not finding it easy to prove the case. And that is why over the years we have never had a decision that is unseating an incumbent president. In addition to that, I think there is also this issue of imbalance between the two teams. When you have a petitioner, it's normally the presidential candidate who lost, along with the political party that sponsored him or her. They are normally represented by a single team of lawyers. On the other hand, you have at least 3 respondents. INEC is always there as a party, as a respondent. The candidate declared winner is also there as a respondent. And then the political party that sponsored the winner is also there as a respondent. 3 respondents, and they are normally represented by 3 different sets of lawyers. And if you consider this, you find that the tax is very, very enormous on the side of the prosecuting lawyers, facing 3 teams. So there is so much imbalance that the other side of the respondents is normally stronger, is normally weightier in terms of quality, in terms of quantity. Even if not in terms of quality, it will be stronger in terms of quantity. And they have more time to actually fight the prosecution side. Unlike the prosecution where they have only 1 team that is given less time than the respondent side. So a combination of these factors actually can explain why it is not easy to unseat an incumbent president through an election petition.
Well, Professor Lawan, the PDP has already responded to say that there's been a subversion of justice in terms of the outcome from that tribunal. They have also insisted that they will go to the Supreme Court. We have not heard yet from the candidate himself, Atiku Abubakar. What's your assessment? What's your reaction to the position taken by the People's Democratic Party? And do you think that the People's Democratic Party will get any relief that it is seeking when the matter goes to the Supreme Court?
First, I think it's expected that they are going to appeal. Cases like this normally end at the Supreme Court. They are very, very serious cases, and normally parties do not leave it at the trial stage. So we expected that they are going to appeal to the Supreme Court. And I think if you look at it, it's good for the development of Nigerian law. A decision has been taken by the Court of Appeal, which is the trial court, on a number of issues. Specifically, 5 issues were raised. And on each of these issues, the court had taken a decision. And it's good for the system to actually test the decision at the higher level, at the Supreme Court, so that we would have a good precedent in the system. If it stops here, then it's not a final decision, and it cannot be as strong as a decision of the Supreme Court. We have, as a source of law, judicial precedent in Nigeria, i.e. decisions given by courts of law, particularly the appellate courts, are sources of law in Nigeria. So by the time we have the Supreme Court pronouncing on these issues raised at the trial court and taking a firm decision on them, then it means we have a final say on these issues, and our law is settled, and there is an addition to already existing jurisprudence in the area. So it's a welcome development, and we expected it. And secondly, on the issue of chances of winning or not winning, we cannot predict, and it's not safe for us to say the Supreme Court would actually either overturn the decision or affirm it. But we can conjecture and say that looking at the fact that all the 5 issues raised in the trial court were resolved in favor of the respondents, it's going to be very, very difficult for the petitioners on appeal to succeed. It's very, very difficult actually to find a decision from the Supreme Court reversing all the ratios on the 5 issues raised at the trial court. But we will wait and see. You never can tell. Anything can happen.
Thank you for that, Prof. Now, in spite of all the flowery praise that followed the judgment from lawyers in the court, I personally, well, 2 judgments were given that gave me pause personally, and I want to get your take on these 2 decisions by the court. In dismissing INEC's motion that Vice President Yemi Osinbajo should be joined, the court ruled that the vice president was merely an appendage to the presidential candidate and therefore does not need to be ruled, to be joined as a party to the suit. I'm quite concerned by that and what that could create in our law for the office of the vice president going forward, to describe a fundamental part of a presidential ticket as an appendage. Yes, it definitely raised my eyebrows, and I want to get your take on that. And also the issue with the tribunal citing the Supreme Court judgment of Kaki and PDP in 2014, where the petitioner appealed to the to the tribunal with regards to the his case against incumbent Governor Gabriel Suswan. And it was held by the Supreme Court that a candidate does not need to attach his certificate to his form CF001. So not attaching certificates, could that not portend something, all manners of fraud in the future? But at this point, we're taking a short break, and I'd love to get your take when we come back from the break. Please stay with us, Prof. Welcome back to the morning show here on Arise News. We're still with Professor Yusufari Lawan, former Dean, Faculty of Law, Bayero University, Kano. Welcome back, Prof. So before the break, I was asking you for your take on 2 points that I found quite striking with regards to the role of the vice president, how he was described as an appendage in the presidential petition. Whereas when President Buhari, well, now President Buhari, then he was the petitioner, appealing the ruling by INEC, which declared Olusegun Obasanjo as president. He joined Atiku Abubakar in that suit, as well as INEC and a plethora of others. So can we discuss the role of the vice president in this regard, and also this issue of there's no need to present a certificate or to attach a certificate to the form CF001?
Thank you for these interesting questions. Question number 1 on whether or not there is a need to have the vice president as a party to the case. That was decided not through the main judgment. It was decided through a ruling that was delivered before the main judgment was delivered. It came as a result of a motion filed by the first respondents, INEC, challenging the entire matter that it was incompetent because the vice president was not joined as a party to the petition. And in the ruling, the court, in my humble view, rightly decided that there was no need to join the vice president as a party to the petition. This is simply because of the fact that by the law, by the constitution, the vice president, they said, in the words of the court, rises with the president and he falls with the president. The candidate that is necessarily required first to stand election is the president, and then as a requirement of law, he needs to nominate someone to support him as a vice presidential candidate. If the president wins the election, the vice president also wins the election automatically. If the presidential candidate loses the election, the vice presidential candidate also loses the election automatically. So he goes with the presidential candidate. And in that regard, if you have the president joined as a party, then there will be no need to join the vice president as a party. In their own view, the vice president is not a necessary party. The law has stricken a balance. There is a distinction between a mere desirable party and a necessary party. A necessary party is a party who must be there. A good decision cannot be taken without that party. A desirable party is a party that is not necessary to be joined. If you join, fine. If you don't, there is no harm. The proceedings can continue. So looking at the constitutional provisions describing the vice presidential candidate during a contest of elections as an appendage to the presidential candidate, I think the court was right in holding that the vice president was not a necessary party to the petition, and therefore the petition could proceed without him. On the second issue of the attachment of the certificate, I think these two, the court was merely interpreting the law. You know, the main function of the courts is to interpret law as made by the lawmakers. And in the process, of course, they make their own law by filling gaps left by the legislators. In this case, what they did was to actually look at the provision talking about the qualifications of a candidate to stand for an election. What is required for a president to have, or a presidential candidate to have, to stand as a candidate? The law says school leaving certificate. And the law has not categorically demanded that the candidate must submit a copy of his certificate to INEC or show an original copy to INEC before he could be cleared to stand for election. That is not a requirement of the law. What is required is attendance. If you can prove by other means that you have attended school, it suffices. You don't have to attach a certificate. A certificate is just one of the ways by which you show that you attended school. In this case, the second respondent brought 7 witnesses, among which was a person who attended school along with the president in Katsina. That person is now 77 years old, and part of the judgment, the second comment made by one of the justices was to the effect that a 77-year-old person cannot lie. The fact that he said he attended school along with the president in Katsina between 1956 and 1961 or so, that was enough to show that, yes, he attended school. And in all the forms he filled, he had indicated that, yes, these are the schools he attended, primary school, secondary school. And according to the court, these are sufficient evidences that, yes, he attended school, and therefore the law does not require him or any other candidate to submit either a copy or original copy of the certificate showing that he attended school. And I think that is not a faulty decision in my own humble opinion.
Well, Prof, so far, are there lessons that can be learned from the ruling of the Presidential Election Petition Tribunal, particularly by INEC? Because the overall objective is not just to deepen jurisprudence, but also to see how we can deepen the electoral process.
Yes, of course, in any election petition, particularly of this nature, there must be lessons to learn, and particularly for INEC as the election management body in the country. They must learn a lesson that whatever they do is liable to challenge. It can be challenged in court. So as they prepare to conduct elections, they must have in mind that people are watching, not only the participants in the electoral process, but the nation is watching, and whatever they do will be weighed, whether they have done fairly or unfairly. And if the losing party is not satisfied, the courts are there waiting, and they can actually look at the complaints lodged by the losing parties. They can't just have it. They fail to do it, that can be challenged, and it can be set aside by the court. So this is a big lesson that INEC should take away. Secondly, I think we are learning from the decision that The judiciary is actually coming up. The judiciary is up and doing. We have a good number of judges who can actually deliver. They have the patience to listen. They have the energy. They have the wisdom. They have the knowledge. And they have the integrity to actually decide cases on merit. And this is exactly what we have seen. The court was there for almost 10 hours. There was only a break of 30 minutes between 1 p.m. and 1:30. And it was only the presiding justice who has been talking from 9:30 a.m. till about 5 p.m. That shows you that actually we have very, very committed judges who are working for the development of the nation, who are ready to make sacrifices. And I think these are important lessons to learn. Other judges should learn from this, and lawyers too should learn from the wisdom exhibited by the team of lawyers who were in the case, the maturity that was displayed, respect for time. These are all lessons that judges, lawyers, and the nation should actually learn from this decision.
Quite true.
Absolutely.
Yes.
But we don't have enough time. I just wanted to take you back to your first point, your earlier point, about the burden of proof. There was the issue of electronic transmission, which is not in the manual, which the court established. But the court also said that the evidence of 5 witnesses is not enough to discharge that burden. So even though Atiku Abubakar has not come out himself to say that he's appealing, only his party PDP has, and then the coalition CUPP, what is your advice for him? In 2 seconds, if you can. If you can.
I said I personally do not see anything wrong in Atiku Abubakar appealing this decision. We are going to enrich our jurisprudence through the appeal process. And normally, when a party speaks, you hardly have the candidate having an opposite view about it. At the end of the day, they will go together. The appeal will be lodged, and we are waiting to see what will happen.
Very much, Professor Lawan. Thank you very much for your insight.